Good morning, everybody. Thanks for joining us. I'm Katie Earle. I'm the coordinator of our University Express program, and we're joined here virtually with Valerie Stanek. Welcome, Valerie.
Thank you.
Glad to have you here. And for everyone on, thank you again because we've got some new folks. So I'll quickly go through our housekeeping. We're recording this session. If all goes as planned, I'll post it on our website in the near future. If you have any questions, we'll communicate with you today through the Q&A panel. So you'll find that located at the lower right-hand side of your screen. If you're on a computer, click on that, expand it, and send your questions to me. And if you're on a tablet or smartphone, touch your screen. That brings up your control panel. You'll see a circle with 3 dots. Click on that, then you'll see your Q&A. So we hope you get all your questions answered. And we'd like to thank our sponsors, which is my Department of Senior Services, Blue Cross Blue Shield of Western New York, Excelsior Orthopedics, and Wegmans for all their support. And Senior Services is at 858-8526 if you ever need anything. All right, the star of our show. Valerie Stanek is an attorney practicing in the area of wills, trusts, estates, and elder law. In addition to practicing law, Valerie is a certified financial planning professional focusing on investments, retirement, and estate and long-term care planning. She lives with her husband and her Morkie, Alfie, in their newly emptied nest in Amherst, New York. Valerie, thanks for being here. It's all yours.
Thank you. Thanks very much, Katie. Good morning, everybody. I'm looking forward to sharing my presentation with you. Please feel free either to ask questions via at the end of this presentation using the Q&A, or if you would like to, I will be giving you my contact information, and you're perfectly welcome to contact me to ask questions about your particular situation. There is nothing that will come back to you in the mail that says that you owe me anything. So not to be worried that you're going to receive an invoice. I also do an initial consultation at no cost to you if you have some questions or would like for me to take a look at something. Today we're going to be talking about the question that honestly I get the most from my clients, and that is, what am I going to do with my house? I know that I can put a beneficiary on my IRA. I know that that there are various ways for me to transfer other assets to my heirs, but when it comes to real estate, I'm not real sure, or I will see clients who get together with me and show me what it is that they did do. And unfortunately, what they did needs to be undone, because if they leave it the way that it is, it's going to cost their heirs unnecessary taxes, or it's going to cause some other type of problem. So basically, this topic is all about getting your real estate, whether it's your home or any other real estate, to your heirs with no regrets. So this is how to avoid the pitfalls of real estate transfers. Whenever I do a presentation, the first topic that I address is prioritizing your objectives, because there are various ways to do everything, and there are pros and cons to every strategy that you might put into place. So it's very important to understand what is the most important thing to you, or what are the order of priority for you in regards to your objectives. So you need to start always with what you're trying to accomplish. Then we're going to go through the various ways that you can transfer real estate. One is just to give it away. Another is to add your children's or other heirs' names to the property. You can do a life estate, which is something that I'll go into in some detail, or you can consider a trust. There are other strategies, but these are the main ones, and the ones that are most often in use. So let's talk about what some of the objectives could be for transferring your real estate. First of all, a lot of people are interested in minimizing delay and expenses. You want to avoid the cost of probate and estate administration, and you want to make the items in your house available before the significant amount of time that has to pass before real estate that passes through your will can be transferred to your heirs or sold. So this is all about avoiding probate. So this is one of the objectives that people have. I know my own mother always used to say, I do not want you kids to be locked out of the house for, a year. I want you to be able to get in there, take what you want, sell the house, do what you want to do. So how do I get that done? Well, that was a very important objective and priority for her. A lot of people also, although they're not aware of this necessarily, but when you talk to them a little bit further, they're concerned sort of on a deeper level of conflict between their children and having a problem with, I want to sell the house. I don't want to sell the house. I want to keep our cottage. No, I really want to get out of it. Well, I don't have the money to buy you out. I mean, so how do we prevent conflict among the children or other heirs? That is something, again, that comes up, but it's more likely to come up sort of after I've had a more lengthy conversation with someone. And it certainly, unfortunately, is more likely to come up when I'm dealing with families who are going through the distribution of their estate, who are distributing their estate in a probate situation. The children are fighting, and it could have been prevented. So this could be one of your objectives as well, making sure that you prevent that type of conflict. Another objective that comes up is minimizing taxes. There are a variety of different taxes to be concerned about, but when it comes to real estate, the primary one is capital gains tax. The tax on the growth in the value of that property from the time you purchased it to the time that it gets sold. And there are rules around this that sometimes get ignored when people do a transfer of real estate to their heirs prior to their death. So that's something that needs to be considered as an objective. There are also estate taxes to be considered, but for most people, estate taxes are not an issue because it requires that you have at least a $10 million estate for an individual. The next is to avoid a lien on your real estate because of a long-term care stay where Medicaid gets involved. If your assets are used up and the only thing that is left is your home, you may be aware of this, that if you go into a nursing home and Medicaid is providing that care, you stay in the nursing home for a couple of years. After you pass away, the house is likely to have, if that's the only asset that's left, because they don't require you to sell it during your lifetime, if that's the only asset that's left, there may very well be a lien on the house. So for a lot of my clients, avoiding a Medicaid lien on their house after they pass away, after a stay in a nursing facility, is an important objective. And finally, some people very much want to have control, even after they've passed away, over who gets what exactly and exactly when they get it. So in some cases, there is a very good reason for example, you may have a very strong desire for the family cottage to remain in the family and for there to be a delay before the family has an option to sell it. You may, on the contrary, want to have your real estate sold, but not have your family necessarily in charge of that. You want to, because some people may want to hurry up and sell it. Some people might drag their feet. So you may want to have a stronger way of controlling when the asset is sold and then how it's distributed, whether it's distributed all at once in a lump sum or whether it's distributed over time. So having that kind of control under, there are certain circumstances where that's very important, is a reason to do some planning around the transfer of real estate. So let's look at the different ways that we can transfer real estate. As I said, the first is to just give it away, to put it in your children's names or in your other heirs' names right now while you're living, so that it isn't in your hands to cause certain issues. For example, I often see real estate transferred directly to a child or to the children during someone's lifetime, because what they wanted to do is be sure that if the person who owned it originally needed to go into a nursing home, they wouldn't have that Medicaid lien on the property. The problem with that is that there are some downfalls and some obstacles. Now, I'm not saying that therefore you should never just gift away your house or your cottage or whatever during your lifetime. You may decide that the obstacles I'm going to talk about are worth it. So let's talk about what is addressed. What are the pros, if you will, to just giving away your real estate while you're alive? First of all, it absolutely takes care of that probate issue. So if your home is in someone else's name during your lifetime, while you're still living there, you don't have to worry that your heirs are going to be locked out of the house. You're not going to have to worry about a delay before they can sell the property. You're not going to have to worry about them being able to get in and get the family heirlooms or the family photographs or what have you. So you avoid that delay. You also avoid the expenses of probate, because there are expenses associated with working with an attorney to work through the probate process, and also just the expense associated with paying surrogate's court. It also helps you potentially to qualify for Medicaid if you are needing nursing care. To not have your house in your name, and it also avoids the possibility of having that Medicaid lien if Medicaid is assisting in your long-term care. It could also help save on estate taxes. Again, that's for a limited number of us. So let's take a look at what the possible pitfalls could be there. Okay, why is this not letting me advance? There we go. So what are the pitfalls? What could go wrong? You could lose all rights to the assets. So you gift that house away, and even though you're living there, your children, heaven forbid, let's hope not, could evict you, could sell the house out from under you, could decide. Now, I'm not saying that your children, that children are evil and out to get you, but even in the goodness of their heart, thinking that they're doing the right thing for you, could put you in an assisted living facility before you are really ready to consider doing that. And you would lose the right. You don't have the right to object. They own the house outright, and they can sell it out from under you. You also, because you've gifted it away, when you give something away, there are no strings attached. So you have no recourse. You can't say, I want my house back. If you are benefiting from a star exemption in New York State, you very likely will lose that star exemption. Very often, people who are in retirement are paying less in property taxes than their working children are would pay, and therefore you would not have that star exemption, especially because you're the one who's living in the house, and the people who own the house are actually typically not living there. You may also fall into the look-back trap, which is my way of saying that 5-year look-back period before, when you give something away, you have to wait 5 years before Medicaid has a claim on that asset that you gifted away, if you should apply for Medicaid for your long-term care. So if you gift your house away and it hasn't been 5 years before you apply for Medicaid for long-term care, you may end up with a Medicaid lien anyway. You want to be aware that when your children sell your house, if you have given it to them during your lifetime, they're going to have to pay capital gains taxes on the amount of the value of the house that represents the growth. Let me explain a little further. You see this bullet point, it says you lose the step up in basis. What a step up in basis is is the IRS giving your heirs a gift when you pass away. The IRS says, guess what? If your parent has passed away and they owned a house, all of the growth in the value of that house from the time they purchased it to the time that they pass away is wiped away. And we are not going to charge you capital gains taxes on any of that growth. So, for example, you bought a house for, let's say, $25,000 50 years ago. It's now worth $250,000. There is potentially a $225,000 capital gain when that house is sold. However, if it is sold after you pass away as an inheritance, all of that $225 of capital gains income is wiped away, and you don't have to pay taxes on that. If you gift that house away 5 minutes before you pass away, all of that $225,000 would be capital gains taxable to your heirs. So let's say you gift away your that same house. It was purchased for $25,000. You gifted away, today, and you pass away in 10 years. Whatever that house is worth 10 years from now, when they sell it, is going to be taxed as capital gain. So that's a significant tax benefit that's lost if you gift real estate away. You may also lose it to your child's creditors. You're living in the house, you put your children's name on it, one of your children goes bankrupt because for example, their business goes bankrupt, or they have very significant medical bills that their health insurance didn't cover, and they've got creditors coming after them. That house is fair game, and you could lose the house to your child's creditors. You could also lose the house in a divorce. If your child now owns your house and they get divorced, the house might have to be sold to settle up at the end of the divorce. So there are all kinds of ways in which just giving away a house can be problematic. So what about adding your children's name to the house? Just you keep your name on it, you add your child's name to it. What are the pros and cons there? The main objective that is achieved by doing that is that it will avoid the delays and expenses of probate. So you avoid probate if you add your children's name on the house. However, here are some of the pitfalls. And there are always pros and cons. So what could go wrong? In order for you to be able to sell the house or to mortgage the house, you would have to have everybody whose name is on that deed sign in order to do that. So you lose a certain amount of control. You are no longer totally in charge. So if you're going to take this, if you're going to use this strategy, and some people do, you need to be very confident that if you decide to sell or mortgage the house, that everybody who's on that deed is going to cooperate with you. Again, if you just put a child's name on your house, you lose that step up in basis. So again, at your passing, your children would have to pay capital gains taxes on not at your passing, I apologize. At the moment that they decide to sell the house, they would end up having to pay capital gains taxes on the entire value of the house. Your child's creditors can go after the house and place. Now, if you're living there, they can't kick you out, but they can place a lien on the house. And your child's spouse can also make a claim against the house in a divorce. And I should also note, what this doesn't accomplish when you put a child's name on the house is it does not avoid a Medicaid lien being put on the house if you should need nursing care. So it doesn't avoid losing house to a stay in a long-term nursing home. So what about a life estate? Some of you may have heard of this and some of you may not have, so I'm going to describe what it is. A life estate is a transfer of your house that sets it up as two periods of time. So now your house is not just an object, it's a stretch of time. So you own, once you put it in life estate, you own the life estate. You are called the life tenant, and you own the house from the time that you transfer it until the time that you pass away. So that life tenancy is yours. You have all of the legal rights to live in the house. You have all of the responsibilities to pay the taxes, and no one can remove you from that house against your will. So you have control over it during your lifetime. At the moment of your passing, the house becomes your whoever's name you put on it. So it becomes your children's, for example. Very typically, it becomes your children's. The objectives that are addressed by the way, just to kind of clarify a little bit, setting up a life estate is very much like putting a beneficiary on your house. It has a very similar effect. It's sort of like setting up that asset with a beneficiary. It's the only way to do that. The objectives that are addressed by life estates are that they allow you to keep the legal right to live there. At the moment of your passing, the house becomes your children's, which means that you avoid the probate process. The lien due to long-term care needs will either be minimized or completely eliminated. Medicaid often just ignores life estates and does not go after any type of return of the value if they've provided for your care. The reason for that is that the value that of your life tenancy is actually very, very small. If you think about it, just that little piece, your life tenancy, can't be sold. There's no actual value to it. So sometimes Medicaid will look at it and will give a small amount of value to your life tenancy and require that your heirs pay them back a small amount when they sell the house. But usually it's quite small, or they don't bother to go through that process of setting up a lien for such a small amount of return. You do retain the step up in basis. So this is a very important point. If you're the life tenant and your children then are on the house as beneficiaries, we refer to that as being remaindermen on the deed. When your children sell the house after you pass away, they do not have to pay capital gains taxes. So they retain the step up in basis. One other point that's very important is you do keep your star exemption if you have a life estate, because you are responsible for paying the taxes, the property taxes. You continue to get the tax break that New York gives you through the STAR program. So with the life estate, what could go wrong? Again, there's the look back trap. During a 5-year period, if you go into a nursing home and you need to apply for Medicaid prior to the end of a 5-year stretch between when you put the house in life estate and when you had to apply for Medicaid, you have fallen into the look back trap, and you may have to still deal with a Medicaid lien. So that 5-year period of time for protecting a house from Medicaid is not something that can be avoided, really. It's always there. There are some very rare exceptions that I won't go into here, but yeah, generally speaking, that 5-year look back period is always an issue. when your children are on the deed as the remainderment, and you are the life tenant, they are the remainderment, it's all set up in life estate. If you do want to sell or mortgage the property, your children have to sign on to that. So you need to be aware of that. So again, you need to be comfortable that whoever you put on there as remainderment, those people are going to be cooperative when you decide to sell or mortgage the property. You want to be aware that the life estate in New York State isn't something that you can use for your rental property or for your vacation properties. It's strictly for your residential real estate, the house where you live. So the next question is, what about a trust? Can I put my house in a trust? You absolutely can. A lot of people don't think of this, but one of the ways that we often use a trust is for specifically for those vacation properties or for rental real estate, for other commercial real estate, because the life estate doesn't work. A trust accomplishes a similar objective. Now, let me just say, just before I go into trust, I'm not going to go into the details of all the rules and the different ways that you could set up a trust, because that would take us too long and it's really tedious. Only lawyers are interested in the details of all of that, I think, for the most part. Most everybody else finds it quite boring. So what I'm going to share with you right up front is I'm talking about a properly established trust that's taking all of the pros and cons and tax implications into consideration. So this is going to be a trust that is specifically designed to handle real estate properly so that you don't end up with I'm not even going to talk about some of the pitfalls if this is not done properly. So what are the objectives that are addressed by putting real estate in a trust? And by the way, just to define trust for this purpose, a trust is really just setting up a separate entity, it's like you're setting up a small business. And you're moving the property, you're changing the title of the property so that it's the trust that owns it instead of you. And by taking it out of your name, it accomplishes some of the objectives that I'm about to describe. First of all, putting it in a trust avoids probate, and it assures your privacy. The reason that privacy is so important is a lot of people are not aware of this, but when it comes to probate, if you have in your will, or you have, even if you don't have a will, you have, let's say, no children, your spouse has passed away, and your heirs include 20 nieces and nephews. Every single one of those nieces and nephews needs to be addressed, needs to be contacted, and they need to sign off before your estate can be probated. So a whole bunch of people get involved. A whole bunch of people see your will. A whole bunch of people find out what assets you have, and it becomes, an issue of privacy. Okay, and so probate is not only a question of delay and expense; it's also a question of privacy and control. With a trust, what you're able to do is keep all of this private. Your trustee knows who's supposed to receive assets and who isn't, and doesn't need to share any of that or any of the reasons, or even contact anyone that your trust is being distributed, that the assets in your trust are being distributed. They don't need to even give anyone who was left out of the trust a heads up. No one needs to know. This is your private business between you and your trustee. The other thing that is accomplished by using a trust is simplicity. Now, a lot of people think of trusts as being very complicated and requiring, a lot of management by lawyers or bankers who charge you a lot of money. Not necessarily. you can set up a trust where a family member, one of your children, for example, is trustee. There are very, very few expenses associated, especially for a real estate trust, because there's really nothing that's being managed in that trust in terms of buying and selling investments and such. So it's quite simple and straightforward. And as I said, when there are multiple beneficiaries, you don't need to do all that very, very tedious and difficult sometimes paperwork of getting all of those beneficiaries to sign off and agree to what you've told the trustee to do. The trustee can just go ahead and do it. So a trust actually in many ways simplifies things. So you may also, because you've gifted this asset away, you've put it inside the trust, you've gotten it out of your hands, whether it's rental, real estate, or a vacation home, or whatever the case may be, it protects that asset in the event that you need nursing care. And it may help you to apply for Medicaid or for VA benefits sooner than you would have otherwise if you had to sell the real estate and use the value of the real estate to take care of you. It also provides for detailed control of what happens to the asset after your death, whether it's money or real estate or whatever the case may be. You can put conditions on your beneficiaries and say you get to share in this, but only if you do X, Y, Z. So in other words, you have to, for example, you have to contribute your share to the property taxes in order for you to continue to be one of the beneficiaries of this real estate. So if you're one of the 3 children who is receiving mom and dad's cottage and you don't pay your share of the utilities and the taxes, sorry, you lose your share. So those are the kinds of conditions that even after your death, you can place on your heirs. You can basically make them cooperate. You can set up the timing for the sale, for example, or the conditions of the sale. You can say that the cottage can't be sold for at least 25 years after my death. So you can set up various rules in regards to timing, in regards to conditions, and you're protecting that asset, the cottage, the rental real estate, the business real estate, from the creditors of your beneficiaries. So creditors of the beneficiaries can't, or your creditors, by the way, can't touch the asset that's in the trust. You also, if it's done properly, real estate that's transferred into a trust allows you to keep your star exemption and also to keep your step up in basis. So under certain circumstances, using a trust, especially if you want to have some of that detailed control after your passing, makes more sense than a life estate. If the situation is more straightforward than that, then a life estate usually is adequate. So as usual, when it comes to any of these types of decisions, it depends on your specific situation, which of these tools makes the most sense. So what could go wrong with this type of an irrevocable trust? Well, the trust is irrevocable, but I put in parentheses here, sort of. So although a trust is irrevocable, or this type of trust is irrevocable, there just so that you're aware, if everyone gets together, the people who put the real estate in the trust, the trustee, and the beneficiaries all sign a document that says we're revoking this trust, you can actually revoke it. So it's not, it's not carved in stone, but it's a little more difficult to undo than some things, but it is undoable, if you will. You need to be aware that that trusts don't protect you from the look-back trap. There's still a 5-year look-back period after you transfer property into a trust before that takes, if you will, for Medicaid purposes. So if during that 5-year period you need long-term care, you run out of other assets, and you need to um, apply for Medicaid for assistance, there may be a period where Medicaid will not pay because they expect you to access the asset that you gifted away instead of asking them for help. So you want to be aware of that look back period and do your planning accordingly so that you don't find yourself in that situation. There are initial trust expenses. Of course, you have to have a lawyer draft the trust. And then there are ongoing trust expenses that usually are with trusts that are primarily for real estate. The ongoing trust expenses are usually minor, especially if you have somebody who is one of the beneficiaries, or one of your children, somebody who's a close family member who's acting as trustee. Those ongoing expenses usually are either eliminated or minimized. If you need to use an attorney for your trustee, then there can be some ongoing expenses. But again, because the work involved in managing this type of real estate trust is usually pretty minor, those ongoing trust expenses for this type of trust tend to be fairly insignificant. Okay, so this is your opportunity to ask questions. This is my contact information for those of you who can see it. For those of you who cannot, what this slide says is please contact me to ask a question or to set up a free consultation. My name is Valerie Stanek, S-T-A-N-E-K. My phone number is area code 716-913-0509. And my email address is my first initial and my last name at ESQ, like lawyer, and CFP, like certified financial planner. So esqcfp.com.
Thank you, Valerie.
My pleasure.
We have some questions here, so let's jump in.
Please.
This first one is, having no children, I'm considering leaving the property to a school or nonprofit. If I do, would we need permission from the entity to take out a home equity loan for repairing or updating the house? We have a home in Tonawanda and condo in Florida. Are you licensed in both New York and Florida?
I am licensed in New York, and I have attorney associates that I can work with who are licensed in Florida. So I can certainly handle anything like that. As far as gifting assets to a charity, it depends on if you're doing it during your lifetime or whether you're setting it up as a testamentary gift. So if you're setting it up to transfer to the charity at your passing, then no, you don't need to discuss with the charity whether, if you wanted to get a home equity line of credit or a mortgage, you don't need to involve them. If, on the other hand, you do your gifting now, then absolutely that would be problematic. In fact, a mortgage lender, if the house has actively been gifted away, may not give you a home equity line of credit or a mortgage. Now, if you have the property in a trust, that sort of is a gray area in between the two, but there are lenders who will work with you if your real estate is in a trust.
Okay, thanks, Valerie. This next one is, I'm aware of a situation whereby a person has both the house they live in and one house used as a rental in life estate arrangement. Is this improper or problematic?
It can be, and it should be looked at. It can be that can some of the benefits of a life estate may not take at the passing of the person who did that. What I can say is it might fly under the radar. You might get away with that, But strictly speaking, now if it's a rental property that the person who owns it is living in, it's different if it's like a duplex. But if it's a rental property that's being used just as a rental property, that that setup is can fail. Let's put it that way.
Okay, thank you.
Mhm.
This next one, how do I transfer money to relatives who are receiving disability payments without hurting their status?
I'm sorry, how can I transfer what to, say again?
How can I transfer money to relatives who are receiving disability payments without hurting their status?
Understood. There are a couple of ways, a couple of considerations that you need to think about. One is if those disability payments, there are two types of disability payment that they can be receiving. One is through one is an SSD payment. The other is an SSI payment. The SSD payments are not subject to a means testing, so they can receive an inheritance without a problem. Somebody who is receiving SSI and is limited in the amount of income and assets that they can have, you need to use a special needs trust. So there are special kinds of trusts that you can set up that can provide that inheritance to someone who is receiving government benefits without disrupting the government benefits.
Okay, great. Thanks, Valerie.
Mhm.
This next one is, in a life estate, will the child who receives the property have to claim the value on a FAFSA form?
So the child who is receiving, who is the remainderman on a life estate, does not need to put the value of the remainder value of the property on a FAFSA. The reason for that is they don't actually control or own the property until the individual who is the life tenant passes away. So their share of that house is what we refer to as um, a future interest. It's not a present interest. So because it's a future interest, it it does not have to go on the FAFSA form.
Okay, thank you.
Mhm.
Couple more things here. Let's see. If you originally enter in a 5-year look back and it then changes to 7-year, are you grandfathered into the 5-year look back?
Well, unfortunately, I'm going to have to answer that with a vague lawyer answer. And the reason for that is because you don't know what the legislature is going to do. That is, that's a law that gets changed. Very typically, when a law is changed that affects people who have made major decisions, like setting up a trust or something along those lines, usually and almost I can't think of one where this is not the case. They do grandfather it. Now, having said that, that doesn't mean that they can't do whatever the heck they want to. So we want to be aware that, I mean, things can change and it is a little bit slippery, but for the most part, I'm pretty comfortable counting on the 5-year look back when I do that type of planning, because so far, anyone who has made a move counting on a certain rule is grandfathered in. For example, when they went from 3 years to 5 years, they did grandfather those transactions in.
Okay, thanks, Valerie. This next question is, what happens if you still have a mortgage on a property?
If you still have a mortgage on a property, it becomes a little bit more difficult. You can still use a trust. You want to double check and make sure that the mortgage company doesn't have something in the contract that says that you can't. But usually you can. And the life estate, if you were thinking of doing a life estate, that would have to wait because you can't do a life estate with a mortgage.
Okay, thank you. This next one, I own 2 properties, one in New York State and the other in Virginia. What is the best way to secure both properties?
Um, the I'm assuming I shouldn't assume. wherever you have your primary residence, that residence, I would use a life estate, or if in Virginia, it may not be exactly the same rules. I would, if that's your primary resident, I would work with an attorney who is licensed in Virginia, and make sure that that was set up properly. They may not even call it a life estate there, but they probably have a similar provision. And then the property that is not your primary residence, I would put in trust.
Okay, thank you. This next one, if you hold a property in New York State, but it's part of an out-of-state trust, how can you transfer that property to an heir within New York State?
I'm going to have you say that again. I apologize.
Nope, that's okay. This is a phone question that I wrote down. So if you hold a property that's in New York State, but it's under an out-of-state trust, can and how can you transfer that to an heir in New York State?
Oh, that's there. That is not the fact that there are what we refer to as reciprocal agreements between the states in regards to trusts, and whatever the trust would need to follow the rules of the other state, but the asset can easily be transferred to the heir, the beneficiary that's in New York.
All right, thanks, Valerie. And then this next question is, so for a life estate with the person still alive, there's a large amount of difference between what I bought the house for and what we will sell it for. Is that difference considered capital gains, or will it be taxed that way in that situation?
If you do, so the question is, if you transfer it into a life estate, what are the capital gains implications? Is that the question?
So if it's already in a life estate and the person who holds the life estate is still alive and then they sell the house, is that considered capital gains?
It could be, yes. What I would recommend, if you have a life estate and you're thinking of selling the house, what I would do is transfer the house. What I would do is redo the deed. Just do a quick claim deed. It's something that I can do quite easily if somebody needs that. You quit claim the house back to you individually and then sell it, because you, as the primary resident of that property, do not have to pay capital gains when you sell the property, unless it's, unless the gain is more than, I have to look at what the number is now, but it used to be 500,000. I think it's greater now even. So if you sell the house and you are the primary resident and you are the only owner, then there's no capital gain. So what I would do is quit claim it back to yourself and then sell
it. Okay, thanks, Valerie.
Mm-hmm.
Then this last question, if an heir is living in a house that I own and paying rent, how can we pass it along after our passing?
So there's an heir living in the house with you, or with the person, or is the heir living in a separate house?
Living in a rental property, paying rent, so separate house.
Separate house. Okay. So there are, I would have to know more. I would have to talk to this individual. So I need more information. You can use, any one of 2 or 3 of the strategies that we were talking about, depending on the circumstances, which one makes the most sense. So please feel free to give me a call, whoever you are who asked that question. I'm happy to discuss it, but I need a little more information.
Makes sense, Valerie. Can you give your phone number again, please?
Yes, sure. My number is 716-913-0509.
Okay, thank you. I'm not seeing anything else come through here, so we'll just give it a second. And while we're waiting, if you want to learn more about trusts, you can come back on June 30th, which is a Wednesday at 2 p.m. because Valerie's going to be talking about what is a trust and who needs one. So we hope to see you back there for that. And now I'm just saying thank you for all this information. You've given us a lot to think about. Thank you. So Valerie, thank you.
Wonderful, my pleasure.
All right, everyone, enjoy the rest of your day. We'll see you later.
Gorgeous out there.